Welcome. Thank you for joining us. My name is Carrie Ciliberto, and I'm the Deputy Executive Director and Counsel at ConsensusDocs. We appreciate you joining us for today's 60-minute webinar. A copy of the recorded presentation and PowerPoint will be emailed to you a few days after the webinar. You will also have an opportunity to ask questions of our speakers. Please type your questions in the questions box, and we'll have the speakers address them at the end of their presentation. I would now like to introduce our speakers, Joanne Brooks, Debbie Griffin, and Mike Zisa. Joanne is the Vice President and Counsel at the Surety and Fidelity Association of America. She previously worked at Fidelity and Deposit Company of Maryland, which became Zurich Insurance Company. Joanne has a Bachelor's of Science degree from American University and also graduated from the University of Maryland School of Law. She is admitted to the Maryland Bar and the U.S. District Court for the District of Maryland. Joanne has co-authored several publications for the American Bar Association and has given numerous presentations for AGC, DBIA, AMAC, COMPTO, USDOT, ACCA, and many other trade associations and panels. Debbie is Senior Counsel in Holland & Knight's Boston Litigation Group and concentrates her practice in the areas of construction, commercial litigation, and bankruptcy. She regularly advises contractors, owners, and sureties on construction contract, administration, and claims matters, and handles construction disputes from start to finish. Her experience includes the representation of contractors, construction managers, owners, sureties, banks, and bank regulators in loan and contract default situations, both before and during litigation or bankruptcy proceedings. Mike is a partner in the D.C. office of Peckar and Abramson, P.C., where he focuses his practice on construction, surety, and government contracts law, and chairs the firm's surety practice group. He represents sureties, general contractors, subcontractors, and owners in all aspects of their business, from contract review and negotiation to contract administration and claims analyses and development to litigation in a number of forums. Mike regularly speaks and writes on surety and construction issues and was recently recognized again by D.C. super lawyers in the areas of construction litigation, surety, and government contracts. We are very lucky to have such prominent industry professionals for our presentation today. I wanted to take just a brief moment to tell you about ConsensusDocs. The ConsensusDocs Coalition is made up of 40-plus associations in the design and construction industry that represent owners, contractors, subcontractors, design professionals, and sureties. Our contract drafting principles are to basically balance risk allocation. We want to make sure that the documents are fair and balanced, they incorporate best practices and industry trends, and we like to say that they're written in the project's best interest versus any one particular party. They are written via a consensus process where equal votes for all coalition members to ensure that all stakeholders in the project have a say in what would be best practice for standard contracts. And in the end, fair contracts will save you time and money. I also wanted to mention that we do have a free pre-qualification and bond form subscription. So if you're interested in checking out the ConsensusDocs bond forms, please check out our website. I will have a slide at the very end that gives you that website. And now I'd like to turn it over to get to the meat of our presentation with Joanne.
Thank you so much, Carrie. I'm going to just give you a little bit of historical context around surety, and some of you may be surprised to know that the first surety instrument dates back to 1790 BC. But if we bring this to the U.S., we'll find that because of the high failure rate on federally funded projects and the burden that was placed on taxpayer dollars, the Congress of the United States enacted the Hurd Act in 1894. In 1935, the Miller Act was enacted, and this is currently the law of the land. The Miller Act requires performance bonds for public works projects over $150,000 and payment bonds for contracts over $35,000. Most states and even local governments have their own legislation that requires surety bonds called Little Miller Acts. Private owners, recognizing the protection that bonding provides, often require bonds even for private contracts. The purpose of the bond is to protect taxpayer dollars by ensuring that projects get completed according to the specifications of the contract and that subcontractors and suppliers get paid for work satisfactorily performed. One critical element to remember is that we must always understand that the bond incorporates the contract. So it's as important to have a fair and balanced contract as it is to have fair and balanced performance bond forms. Now, yes, Michael.
Hello, everyone. This is Mike Zisa. So why are the particulars of a bond form important? As you all know, bonding is an essential component of the construction industry. Payment and performance bonds are required on most significant public and private construction projects. Despite being ubiquitous in the industry, the particulars of the bond form being utilized on a given project are often overlooked. However, it's essential for all of the players, the owner, the general contractor, subs, the surety, to understand the type of bond form that is being utilized. Why? Because not all bonds are created equal. The bond form defines the rights and obligations of the parties. A good form leads to predictability and enforcement, which reduces disputes and litigation. Now, for me, as a construction litigator, that's not a good thing. But for the players in the construction industry, ensuring that the bond has clear terms that are fair and reasonable is essential and will lead to more efficiently and smoothly operated construction projects. Next slide, please. So, what are the common forms that we see out there? Well, first, there are indemnity bonds. An indemnity bond provides that the surety is responsible for all costs resulting from the bond principal's failure to fully and faithfully perform the contract obligation. That's it. There's no notice requirements generally. There's no explanation of the surety's performance options. Now, of course, there's a substantial body of case law defining the rights and obligations of the parties under an indemnity bond, but decisions vary by jurisdiction, and some decisions are contrary to the majority of the law on surety bonds. This can lead to uncertainty in what the parties' obligations and rights are, which in turn leads to disputes and litigation, which increases costs and can slow down construction projects. Then there are Miller Act and Little Miller Act bond forms. And these forms and the terms of the forms are generally defined by statute. There's the U.S. Code that sets forth the terms and the conditions of the Miller Act bonds, and then each state will have its Little Miller Act statute, which will define the terms of these bonds. And of course, these bonds are used for federal government and state government construction projects. Then there are also custom forms, and often these forms will be similar to the more commonly used forms that we're going to discuss today, but with modifications that may make the forms more onerous or more one-sided, and this may lead to uncertainty in their enforcement and, of course, increased costs. And the final group that we commonly see are the ConsensusDocs bond forms and the American Institute of Architects bond forms, which are commonplace in the industry. As Carrie said at the outset, these forms are the result of input from various industry players, so they're prepared to be balanced and not one-sided. Now, Joanne is going to discuss some of the onerous bond provisions she sees in the marketplace.
Thank you. Yes, the onerous provisions, I just want to say at SFAA, we engage on behalf of our members to address onerous bond provisions almost on a daily basis. The impact of having onerous provisions tends to be that one party is unduly burdened, and that party generally is not in a position to bear the risk. So what we also see is that the owners want to expand coverage of the bond to cover risks that should be covered by other insurance policies. The outcome from all of this is that we often see that competition is hampered when there are onerous provisions. Often the contractors or the sureties will not be able to participate because of a provision, and that's not good news for us. Also, we may see that the pricing on the projects when there are onerous provisions seem to be higher as contractors are trying to deal with the contingencies and mitigate risk. Onerous provisions also tend to flow down to lower tier subcontractors. Those that don't have the strongest balance sheets often are eliminated from the process. And this also has a negative impact on just getting participation for minority subcontractors as well. Now, some of the examples of onerous provisions that we see are listed on the slide here. Anything that has an automatic increase of penal sum, consequential damages, long-term warranties, waiver of notice of default, short takeover times. You've got 3 days to make a decision on a $100 million contract, what should happen, or any provisions that limit the surety's options. These are all kinds of things that we actually see often, and we write letters, and most often actually we get people, once they understand what the impact is, to concede. But the importance of the consensus docs in this regard is that we see consensus docs as a balanced and fair form, and they don't contain the provisions that sometimes we find offensive as sureties. I will say, since we've got some people on the phone, give you a little bit of extra credit for actually participating in the webinar. Another onerous provision that we tend to see a lot is the requirement for an A+ rating of sureties, because that really takes out a large number of sureties, and an A- is an excellent rating, and so if a rating is required, we generally say that it should be A-. And I think that's about it. I think we're going to move into our performance bond now.
Right. So thank you, Joanne. So we're going to now look at the consensus doc performance bond form and the AIA performance bond form, the current version of the AIA performance bond form, and we're going to compare and contrast some of the different key terms of these forms. So a significant feature of a performance bond that must be understood is how to trigger the surety's obligations. As I explained earlier, there are indemnity bonds which don't identify any preconditions to the surety's obligations, which some may think is great. But as I said, this can lead to uncertainty and disputes. Both the AIA and the consensus doc forms expressly identify the conditions to trigger the surety's obligations. As an initial matter, both forms require that there be no owner default. In other words, the owner has to be fully and properly performing its obligations under the contract, and the owner must agree to make the outstanding contract balance available for the completion of the contract. After those similarities, however, the two forms differ on the conditions to trigger the surety's obligations under the bond. Under the AIA form, there are multiple conditions preceding. First, the owner must send a notice to the contractor and the surety that the owner is considering declaring the contractor in default. It's not a declaration of default, just they're considering it, they're thinking about it. In the notice, the owner can request a meeting with the contractor and the surety. If the owner does not request a meeting, the surety may make the request, but must do so within 5 days of receiving the notice, and the meeting must occur within 10 days of the initial notice that the owner provided. Now, this is a slight change from the earlier version of the American Institute performance bond. In the 1984 version, the meeting was required; it wasn't optional. So this is a distinction from the older version. But the final step that's necessary under the AIA to trigger the surety's obligations is the owner must declare the contractor in default and terminate the contract, and of course provide notice of the same to the surety. Until all of these steps are followed, the surety has no obligations to perform. And I've been on both sides of this issue. I've represented the surety, and I've represented a contractor. And it really is essential that all these conditions be satisfied, because it's well settled that if they're not, the surety just doesn't have an obligation to perform. You don't get to the next step without checking all these boxes and satisfying those conditions. Now, under the consensus doc, it's a bit more straightforward. It's simply the contractor is in default and is declared to be in default. Once that happens, then the surety's obligations are triggered. So what are the pros and cons? And that's what we say on the slide. But it's not that one of these forms is better than the other. Rather, it's understanding the differences, because whether it's a pro or a con is really in the eye of the beholder. Under the AIA form, as I said, there's multiple steps, including the meeting, and this process may take longer, but it gives the parties the opportunity to sit down and talk and possibly resolve this dispute and get the contractor back on track without a default and without the surety's prolonged involvement in the project. The AIA also requires termination, and as everyone knows, termination is a very drastic step, and that may not always be the best thing for a project. The consensus doc, as I said, has one step, the declaration of default, and it's not necessarily a termination to trigger the surety's obligations. So really, you have to understand the differences, and there are pros and cons, and it really depends on who you are and what your perspective is on how to get your project done. But once you've triggered the surety's obligations, then in both of these forms, it moves on to what performance options the sureties have. And Deborah Griffin is now going to provide an overview of the surety's options.
Thank you, Mike. On the slide that's up on the screen now, we list the 5 options that are typically considered once the preconditions to a surety's obligation have been met. We're going to go through each of these in the slides that follow. The options are completion by the contractor, completion by the surety, which is sometimes referred to as takeover, tender, pay and walk away, or deny liability. So let's get started with the first one. Next slide. The first option we're going to talk about is completion by the contractor. Why is this an option, and when might it be the one that is utilized? Completion by the contractor is most often utilized as the resolution of a bond claim when the parties consider that the contractor has the technical competence to complete the work, but is hampered in its ability to do so, usually by financial difficulties, things of a short-term nature. So what often happens is that in response to an owner's notice and declaration of default, the surety will work out some kind of financing arrangement to provide the short-term help that the contractor needs to get over the hump and get the job done. This option leaves intact the contractual relationship between the project owner and the contractor. So there's no new party coming in that's a stranger to the project to see it through. But in order for this to work, the surety needs the owner's consent. That's because if the owner has gone through the steps of declaring a default, and if we're talking about an AIA form, a termination of the contract, they shouldn't be in the position of having that same defaulted contractor foisted back on them by the election of an option without their consent to doing so. So both the ConsensusDocs form and the AIA form require owner's consent in order for this option to be selected. On some of the other bond forms, the ones that don't necessarily lay out what all the options are, it can lead to a dispute about whether this is an option the surety can elect without the owner's permission, thus illustrating the point that has been made already that having a bond form that is clear in laying out options can reduce disputes. Next slide. The second option we're going to talk about is completion or takeover by the surety. Let me describe how it works first, and then we can talk about what the advantages are. In this situation, the owner has declared a default and under the AIA form has terminated the original contract. The surety and the owner then enter into a new contract, usually called a takeover agreement, whereby the surety steps into the role that the contractor was in as the one in privity with the project owner to get the job done. However, because sureties are not contractors, they almost inevitably have to hire a new completion contractor to come in and actually carry out the work. In order to implement this option, usually sureties will make arrangements with the existing subcontractors and try to keep as many of them on the job as possible, and assign those subcontracts or make those subcontracts available to the new contractor to carry out the work. So the new contractor is actually managing, in most instances, the existing subcontracts. Under the ConsensusDocs form, the surety cannot elect this option without getting the owner's consent. The AIA form does not require owner consent for this option. The pros and cons of this option are that the surety stands between the owner and the new contractor and makes sure that the new contractor performs in accordance with the original plans and specifications. Some owners feel that this is an advantage because it keeps the original surety on the hook and engaged, and that there's an advantage to that. So this option is most often selected when the surety, when there's some uncertainty about the scope of work that needs to be done, or if the pricing needs to be on a basis other than the pricing structure for the original contract. So for example, if there's an uncertain amount of work left to be done, the surety can contract with a new contractor on something other than a lump sum, such as a cost plus reimbursement, with or without a guaranteed maximum price. That type of pricing is not necessarily available under some of the other options. Next slide.
So the next option is tender. Both the AIA and ConsensusDoc performance bond allow the surety to tender a completion contractor. So what exactly is a tender? In short, this option allows the surety to arrange for completion of the contract by tendering a contractor who enters into a direct contract with the owner. So unlike a takeover where the surety has a contract with the owner, in a tender, the owner is going to have this direct contract with the completion contractor. In addition to tendering the completion contractor, the surety must pay the difference between the remaining contract balance and the cost to complete the contract. Under both forms, the owner must consent to the contractor tendered by the surety, and the tendered contractor must provide new payment and performance bonds. So what are the pros and cons of a tender? Well, from the surety's perspective, it gives them the ability to control its loss under the bond. In other words, the surety is going to look at, okay, I have a remaining contract balance of X, and it's going to cost me Y to complete the contract, so they can determine quickly exactly what their loss is going to be, or their cost that they're going to incur. And they can, if it's an acceptable amount, they can pay that amount, and they're done. They're off the project, assuming, of course, that the owner accepts the tendered contractor. So that's certainly an advantage for the surety. There's going to be, as I said, new payment and performance bonds, so their bonds are released. For the owner, it gives them a direct contract with the contractor that's going to be performing the work, as opposed to having to deal with the surety. As Deborah explained, in the takeover scenario, the surety is going to be the contractor in name that the owner is going to deal with, but the surety is not going to be actually performing the work. They're going to be effectively subbing all of the work out, which just gives another layer or level of in the communication line. So For the owner, it's appealing because they have this direct contract. They have the new payment and performance bonds in place for protection. So what are the cons or the catch with tender? Is that it's not always a viable option. You really must look at each project very carefully to determine whether a tender is going to work. Normally, it can work early in the project, but the further along the project is, the harder or less likely tender is a viable option, because there's work been performed. So there's going to be warranty obligations and accepting work performed by others, which could some contractors won't be willing to do, or it's going to increase the cost to a point where it's just not a viable option. Next slide.
So I'm going to talk about the payment of damages, or can the surety just pay and walk away? And to that, the answer is yes. Under both options, there is the ability for the surety to decide to pay damages up to the penal sum. Under the AIA version, the AIA requires a prompt investigation and a determination by the surety as to its liability to the owner up to the limit of the bond. The category of damages seem to be a bit broader and include legal, design professional, and delay cost. If the owner refuses the payment, the owner can enforce any remedy available. Under ConsensusDocs, the surety may waive its right to complete and then reimburse the owner the amount of its reasonable cost not to exceed the bond sum. The two bond forms are distinctly different, as the ConsensusDocs version is looking at reimbursement, while the AIA form looks at payment up front. Reimbursement allows for the owner to move forward with completing the project and delays any litigation until after the project is completed. So that might be considered a pro. Using the pay and walk away, generally I've seen it done at the end of contracts where there's smaller amounts of work to be completed, and the owner may want to just self-perform that work if they can arrive at a reasonable dollar amount for completion. Or sometimes at the beginning, when the contract really hasn't begun, you could say, you know what, here's what the damages will be to get another contractor there, and you guys handle it because you seem to want to do that. So that might be another option. So pay and walk away is an option, and I think ConsensusDocs, the fact that it's after the fact, I mean, there could be disputes around the reasonableness of the expense if an owner gold plates a project or something like that. But generally speaking, I think that that's probably a good option to try if it makes sense under the circumstances. Next slide.
So the last option we're going to talk about is where the surety denies liability. This is an option because not all declarations of default are conceded by the surety or the bond principal to have been justified. So usually there's a denial of liability where the defaulted contractor is contesting the propriety of the declaration of default or the justification for termination. Sometimes sureties side with their bond principal and will deny liability. In other instances, the surety's denial of liability is based on its own assessment of the situation and its determination that there are defenses to the bond obligee's claim. Those defenses can include surety defenses that are specific to the surety, but it could also include defenses that the defaulted contractor would have had, because the surety is entitled to assert all the defenses of its bond principal, with the one exception of bankruptcy. So usually the way a denial of liability plays out is the owner declares a default, and in the case of an AIA form, terminates the contract, notifies the surety, says to the surety, do what you have to do. The surety notifies the owner back that they're going to deny liability. At that point, the owner knows the surety is not going to be arranging for completion, so the owner is in control of the completion process. This is similar to the pay and walk away option, except that there's the dispute and uncertainty about whether the owner is going to recover anything once the dispute has been resolved. So the owner has the option of completing the project the way they want and also controlling when it is they submit a bill to the surety. It usually makes sense for the amount of damages that the owner is looking for have become relatively certain, not necessarily fully liquidated, but it certainly makes sense to have a pretty good handle on what the damages are going to be. The owner that is controlling completion often will have the opportunity to retain the original subcontractors that were working for the defaulted contractor. Many contracts that they sign for the prime construction contracts have provisions in them whereby the contractor makes a conditional assignment of its subcontracts to the owner. So after the contractor has been defaulted, the owner has the option of taking that assignment, assuming the obligations under the subcontracts to the subs, and then seeing the work through with the original crew that started the work. This is often a way to mitigate damages because you retain the warranty and the obligations of the subcontractors to correct any defective work that comes up. Obviously, if there's a dispute between the owner and the surety, there's not going to be consent, and that's not a requirement for the surety to deny liability. Next slide.
So is there a cap to the surety's liability? Or said another way, when is the bond sum or the penal sum the full extent of the surety's liability? Under the AIA version, if the surety chooses the options of completion by the contractor, tender, or payment of damages, the cap is the bond penalty. If under the AIA version we choose the takeover option, the penal sum may not be the full extent of the surety's liability. Under ConsensusDocs, it explicitly states that the bond sum is the maximum amount of the surety's obligation regardless of the option selected, and the owner maintains control through the requirement of consent. So that's the answer to that. Next slide.
The next issue we're going to look at is the limitations period under the bond forms. In other words, the time limit in which a party has to file a lawsuit against the bond. So under both the AIA and the ConsensusDoc forms, there's a 2-year limitation period on filing a lawsuit. The one caveat is both say unless it's prohibited by law where the action is being filed. So in other words, then the statutory minimum period for filing a lawsuit under a performance bond would apply. The key to understanding the limitation period is the event that starts the clock running. Under the AIA form, there are 3 potential triggers. The first, a declaration of contractor default. The second is the contractor stops or ceases working. Or the third is the surety fails or refuses to perform its obligations under the bond. And it's whichever of these events occurs first. Under the ConsensusDoc form, there are 2 potential triggers: default of the contractor or substantial completion of the work. And again, it's whichever of these events occurs first. So certainty about the occurrence of events, occurrence of the event triggering the limitations period is key. Now, both forms identify distinct and significant events to provide certainty. But I'll tell you that there's still many disputes involving these issues. And I've litigated cases over when the contractor was first in default, when the first declaration of default, the first notice was made, when the contractor stopped working, and when substantial completion actually occurred. And the reason I say that is it's to focus everyone. It's essential for a party to understand the triggers and then to keep a close eye out for events which may start the clock. And again, as we said earlier about the pros and cons, it's not that one is better than the other. It's just understanding the obligations to bring a claim and look for the events that could trigger the clock running. Next slide. We're now going to move on to looking at the ConsensusDoc and the American Institute of Architects payment bond forms. And we're going to, again, compare some of the key terms of these forms. Next, the first, under the payment bond, key component is who is entitled to make a claim against the bond. While there are certainly similarities between the AIA and the ConsensusDoc forms, there are also several differences to note. Both allow for an individual or an entity having a direct contract with the contractor or having a contract with a subcontractor of the contractor to assert claims. I know that's a mouthful, but simply put, both forms allow first-tier and second-tier subs to make claims against the bond. Now, the AIA form adds that an entity or an individual who has rightfully asserted a mechanics lien against the real property may also assert a claim. Therefore, depending on the jurisdiction's mechanic lien statute, third-tier or even lower-tier subs and suppliers may also be entitled to assert a claim against the bond. For example, in Maryland, there's no limit on the tier of sub or supplier that can file a mechanics lien. Thus, they would be able to also file a claim against the payment bond, or the AIA payment bond form. The ConsensusDoc form does not include this extension or the broadening of the category of claimants. It's limited to the first and second tiers. The AIA form also includes a non-exhaustive list of the types of labor, material, and equipment that fall within the coverage of the bond. They identify costs for water, gas, light, heat, oil, phone services, rental equipment used for the contract, and they also specifically identify architectural and engineering services. The ConsensusDocs form does not specifically identify these items. Now, that's not to say that they're not going to fall within the coverage of the bond, but they're just not expressly identified. So, pros and cons, again, it's really in the eye of the beholder. Whether you're an owner, general contractor, or the surety, there are certain advantages and disadvantages that must be considered when selecting bond form. Next slide.
So what are the conditions that trigger a surety's obligation to do something under the payment bond? In both the ConsensusDocs and AIA forms, the primary condition is that the contractor, the bonded principal, has failed to make prompt payment of amounts due under their contracts with subcontractors and suppliers. Now, certainly, there could be a dispute about whether an amount that a payment bond claimant is seeking was in fact owed, but for purposes of triggering the surety's obligation, the claimant needs to be in a position to at least allege that the contractor has failed to make payment of amounts due. In addition, for claimants who were not direct subcontractors or suppliers to the bond principal, they're referred to as second-tier claimants. They have to wait until payment has been not yet made for 90 days after that claimant's last work. The AIA form has no such waiting period. Next slide. So both the performance bond and the payment bond name as the bond obligee the project owner. And yet there are differences between the forms about whether and to what extent the owner actually has rights under the bond. The ConsensusDocs form doesn't answer that question directly. Under the AIA form, on the other hand, there's express coverage granted to the owner for the defense of mechanics liens. The project owner's ability to assert and enforce those rights under the payment bond depend upon three preconditions. One is the lack of owner default. Two, the owner has to promptly notify the contractor and the surety that it's aware of a claim, a mechanics lien claim that's been asserted by a sub or supplier of the contractor. And the owner has to tender defense of that claim to the contractor and the surety. Next slide.
So can a second-tier claimant immediately pursue a claim under the bond? Under the AIA version, the answer is yes. Historically, under AIA in 1986, they had a ripeness requirement, but that was eliminated in the 2010 version. Under ConsensusDocs, however, the claimant must wait 90 days. I think there's an advantage to that waiting period, as it gives the GC, general contractor, the opportunity to resolve some of these undocumented claims. It probably cut down on the number of actual claims filed against a surety, and avoid premature costs that might start to accumulate. It also gives the subcontractor the opportunity to gather its documentation to make its strongest case when the claim is ripe. So those are the rules with regard to second-tier claimant rights. Now, next slide, let's see. We are looking at the payment bond notice requirements. And if you're a direct contract subcontractor, under the AIA version, you must send a claim to the surety. And there is no such requirement under the ConsensusDocs. And I guess that would be something that subcontractors would like, because then they don't have to preserve their rights and do anything affirmatively. So it cuts down on their paperwork. With respect to the lower tier subs, on the next slide, you'll see that written notice is required under both forms. You must state with substantial accuracy the amount of claim, and you must name the party to whom materials were or equipment was furnished or supplied within 90 days. Under AIA, the notice of claim is sent to the surety, and if notice of non-payment was given by the owner, that would satisfy the claimant's obligation to furnish notice. Under ConsensusDocs, you must send your notice within 90 days to the, if you've worked within 90 days, to the contractor, the owner, and the surety. Since there's no privity of contract, this seems to be a good option so that everyone is on the same page and is aware of the fact that there's a claim being made. Next slide.
So what requirements are there regarding the time within which a surety has to respond to a payment bond claim? ConsensusDocs doesn't specify any time period or deadline. Under the AIA form, however, there's a specific provision that says the surety must respond to the claimant's claim within 60 days of receipt of the claim. But this is not a requirement with terribly sharp teeth. The failure of the surety to respond within that time period does not waive defenses that belong to the contractor to the amount claimed. It would, however, waive defenses to the extent that the amounts that the claimant is looking for are undisputed. The other requirement that's stated in the AIA form is that the response by the surety must state what the disputed amounts are and the basis for the dispute. Next slide.
We're now going to just look at the limitations period to bring a claim against the different bond forms. As with the performance bond forms, the payment forms for the American Institute of Architects and ConsensusDocs have the same limitations period. Here it's a 1-year limitation period on filing a lawsuit, unless, again, it's prohibited by the law where the action is being filed, in which case the statutory minimum period would apply. Again, the key to understanding the limitation period is the event that starts the clock. Under the AIA form, either the claimant sending notice of the claim to the surety or the last date that anyone provided labor, materials, or equipment to the project will trigger or start the clock running on the limitations period. And it's whichever of these events occurs first. Under the ConsensusDocs, it's the last date that the claimant provided labor or materials or equipment that will start the clock running. And that the ConsensusDoc has the same triggering event as the Miller Act payment bond, which is tied to the claimant's performance of work. Again, the pros or cons, it comes down to certainty. The date the claim was made is seemingly would be easy to determine because you're going to have the notice of claim, and that would start the clock. The last date that anyone provided labor or materials, well, it's not as simple of an inquiry. A project may have dozens of subcontractors and suppliers, and so for anybody to make the determination of when the last date that work or equipment was provided at the project is a little bit of a more challenging inquiry. The last date that the claimant provided labor or materials kind of falls somewhere in between on that spectrum of certainty. It's limited to the claimant, so now you're just looking at one person, but you have to determine whether the work or materials or equipment that was being provided is sufficient to continue the limitations period. For example, remedial work, so coming back to correct deficient work under the case law does not toll or extend or restart the statute of limitations. So it does still take some analysis to determine what event if the statute of limitation has been triggered. But the key is understanding the trigger and carefully monitoring the events that could start the clock.
Well, thank you, Mike, Joanne, and Deb. And while I gather questions here, Joanne, I think you had a comment you wanted to make.
Yes, I just wanted to point out that the ConsensusDocs acknowledges the difference between procurement methods and types of contractors, so issues are more accurately addressed. So if we look there, we talked specifically about the performance and payment bonds under ConsensusDocs, but I wanted everyone to be aware that there's a design build performance bond where the surety is liable for the design cost of the work, and one where the surety is not liable for the design cost of the work, as well as a payment bond where the surety is liable for design costs, or a payment bond where the surety is not liable for design services. And we also have a subcontractor performance bond, a subcontractor payment bond, a subcontractor bid bond. And there's also a bid bond form for ConsensusDocs.
That's correct. And all of these bond forms you can now get free through a subscription I put the website there. But let's turn now to some of our questions from our participants. Joel asks, why doesn't ConsensusDocs have the notice of considering in the meeting? Having been through this once as an architect, it seemed useful.
Joanne, do you want to address that? We had talked about that a little bit in preparing for this.
I think that what happened was that there was debates over the meeting. Sureties, on our side, we like to have the meeting. But I think that actually in the discussion for ConsensusDocs, the concept behind ConsensusDocs is that we're working in a collaborative way. And so when that's sort of contemplated for people who use ConsensusDocs, so the concept of meeting isn't, to mandate a meeting isn't something that should be required, because it would make good sense to do it. You're not prohibited from having a meeting, so it would just be in the natural flow that you would want to have a meeting. But I think that some of the owners don't like the meeting, the requirement of the meeting. So sometimes they'd rather not have that listed. So I think that because, as we said, that this is a group of all different types of stakeholders involved, it was determined that for the purposes of consensus docs that it wouldn't be mandated, but the concept is that it still would be the best practice in a sense. And
I'll also add, from my experience, when there is a declaration of default, the event that would trigger the surety's obligation under the consensus docs, representing the surety or the bond principal, the first thing I do, or maybe not the first, but one of the top three things I do is I ask for a meeting. And I say, it makes sense to get the stakeholders in a room together so you can describe to me what's happening and we can have a discussion and see how we're going to resolve it. That to me, certainly for the surety, that's part of the investigation. You're going to see a letter saying there's a default, here's what it is. You're going to talk to your bond principal. You're going to maybe talk to the obligee, the person declaring the default. But sitting down and talking about it and oftentimes going to the project and seeing what's at issue helps the surety investigate and helps possibly find a quick resolution, but it certainly is part of the investigation.
Okay, great. Let's go to the next question. For contractor completion and needing owner consent, does that mean the owner needs to rescind the default and termination?
For which completion? For contractor completion?
For contractor completion, correct.
Usually, yes. That would that would require at least a suspension, and it ought to be documented in writing. It also is helpful for the parties to try to work out, if possible, the circumstances under which the owner could reactivate the declaration of default without having to come up with a new basis for doing so.
Thank you. Another question here is, when bond forms are included in the bid package, is there ever the ability to change the quote-unquote required form to a more equal document such as the consensus docs form?
I think yes. I think that normally comes when you have the opportunity to respond. Oftentimes SFAA will write a letter about a specific bond form and suggest consensus docs as an alternative, to try to, especially if there are a whole host of onerous provisions within a bond form. So there's the opportunity to raise that, and it's often great for the contractors as well to write letters and, object to the forms of the bonds, because that's really, if no one's going to bid the project, it'll become a problem for them. So that's really kind of where the power comes in determining if the forms are too onerous, then they shouldn't be able to get bidders. And so we have had success in the past with, but a lot of it comes down to educating people about why their form is not really writable.
Let me just add to that response by saying that whether it's feasible to try to change a required bond form really is going to depend on how many bidders there are and how close the bids are to one another. And for private procurements, you don't necessarily know how many bids came in or how close the prices were. So there's some risk to a contractor pushing back on the bond form because they don't know whether it's a small price for the owner to pay to go to the next low bidder if that other bidder is not pushing back on the bond form.
Yeah, I think usually we see the bond forms before the bids, and so most of our letters are written pre-bid when we're trying to get them to change some provision. And I will say that oftentimes the contractors go to their sureties and say, you tell them no, because I don't want to. So, sometimes we're in that position of being the bad guys because the contractors don't want to somehow upset the apple cart in that way.
Good point. Next question. In my state, only a general contractor can subcontract work. So if the owner was to take the job over, they would have to become a contractor. So getting the subcontracts assigned might not help them out unless they could turn those subcontracts over to another GC. Am I missing something?
So I'm not familiar with exactly how the law would be worded that would limit that. I mean, it seems to me that an argument could be made that the owner is not entering into a new subcontract. They're just administering a subcontract to which it succeeded, and that it's doing so is within the contemplation of the law.
Yeah.
I don't know whether that works.
That's right. I mean, the owner wouldn't be performing any work. They would simply be, the contractors, who are subcontractors, would be performing the work directly for the owner, just like a general contractor would be performing the work directly for the owner.
Okay, another question is, who pays or how are liquidated damages handled?
Well, that's usually determined in the contract. And so, as I said that in the opening, whatever the contract says regarding liquidated damages, normally the bond would pick those up as damages that are compensable under the bond. We fight about these a lot too, when they're excessive. But we do, sureties do pay liquidated damages.
And then a follow-up question from that one would be, who pays to get the schedule back on track?
Yeah. Well, sometimes do you want to say something, Mike?
Well, I was going to say, I mean, again, what Joanne had said, if it depends on the terms of the contract. I mean, if it says that the subcontractor in this instance is responsible for all costs associated with accelerating work or supplementing their forces to achieve the project schedule, then that would be incorporated into the bond and would be arguably part of the costs that the surety would have to incur or be responsible for.
Okay. Another question here is, it looks like referring to the ConsensusDocs 260 and 261, how will state laws that differ affect surety response in light of 90-day and no notification requirement?
So if what you're talking about is state law requirements that are different from the content of these bond forms, I believe both bond forms have wording to the effect that if there are time limits contained within the wording of the bond and those provisions are not enforceable under state law, then the bond is deemed to be modified so that it does comply with state law.
Right. I agree with that, yeah.
That's correct.
Great. And it looks like question here of, do the ConsensusDocs have P3 bond forms? And I can answer that. We do not have a P3 specific bond form yet, but it's comments like these that help us determine which forms and standard contracts we should be working on. So I will make a note of that. And we are working on. I think our drafting committee has been working on P3 forms. We haven't gotten them there yet. Yeah.
It's difficult on P3. It's very difficult because P3s are just so individual. Each one is its own thing. So generally speaking, most entities haven't been able to come up with a template that matches P3. So there are some people who have, but it's difficult because you got to make enough changes that it's almost, is it worth it? I'm not sure.
I'm sorry, Deborah.
The other approach that's taken is to push the bonding down to the trade contractor level, and with many of the trade contractors are not part of the P3 team, the P3 negotiation. So then you could use a standard form for the trade contracts.
I think Michael was going to say something.
Well, no, I was just going to say, in our experience at our firm, each P3 project, the bond form has been an independent negotiation. I mean, we've started with the basic bond form, and then it has been modified to suit the needs and the requirements of the various stakeholders in the P3.
Great. Well, I've got 3 o'clock here, and out of respect for everyone's time, I'm going to wrap it up. The remaining questions I will forward to the speakers so that they can respond to you directly. I want to thank you, Joanne, Debbie, and Mike, for a very informative presentation, and I want to thank our participants for joining us today. Please do take a moment to complete the evaluation form that will be emailed to you, along with the recording from today's presentation. That'll take a couple of days for us to get that out to you. But your feedback will help us when you fill out the survey to plan future educational events. This will bring our program to a close. I hope you all have a very happy and healthy holiday season. Thank you.
Thank you.
Thanks.